Yes, Your Honor.
Okay. I can't tell whether sometimes we're loud or we're soft, and so I figured this time I would ask if you could hear us. Okay. With regard to this matter, Attorney Wheeler, I understand you represent the appellant in this cause.
Yes, Your Honor.
Did you wish to reserve any time for rebuttal?
Yes, Your Honor. 5 minutes, please.
Okay. I will do my best to let you know when you get to 15 minutes.
Thank you, Your Honor.
Okay. With that, we are ready to proceed.
Thank you. Your Honor, may I just also mention that my client is with me here today in my conference room, participating in the argument. We are challenging a final judgment on relocation rendered by the circuit court while it was sitting in its review capacity of proceedings conducted by the general magistrate 4 years earlier. We submit that this was all done pursuant to untimely exceptions, which we'll discuss in greater detail. And in the process, of course, the circuit court rescinded a prior order, which we are now calling a partial final judgment pursuant to Westwood versus Westwood, which previously had permitted my client to relocate with her daughter to Oregon. And in fact, she and the child had lived in Oregon since April of 2015, April the 8th, 2015. We'd like to focus on two of our issues for our purposes today. We believe that these first two issues entitle us to a reversal, and that will take care of many of the other problems that we are arguing in other issues as well, with the exception of the need to clean up orders on contempt that were completely unfounded. And our first argument, Your Honor, we would submit that the circuit court exceeded the scope of its authorized review and the authorized standard of review as outlined in Rule 12.490F. That rule requires the circuit court to confine itself to the record on appeal compiled by the magistrate, as that record is described in subsection G. And of course, our judge did not do that. He allowed continued ongoing evidentiary hearings. They began in October 2016, and they continued through September 2018 on the issue of redefining the parenting plan. The circuit judge also did not use the appropriate standard of review. Case law is very clear that he is to determine, just as this court is to determine, whether the magistrate's factual findings are supported by substantial competent evidence and whether her legal conclusions correctly reflect Florida law or are clearly erroneous, and whether she has misconceived the legal effect of the evidence. In this case, the judge went far afield of that in some respects. Earlier in the course of the litigation, he indicated he had no complaint with the magistrate's findings of fact. At a hearing on February the 2nd, 2017, he said he was accepting the findings in the report and recommendation, and that he felt they were valid as of the date that the court entered them. Apparently, he was not convinced that he should stay solidified on those findings, given the passage of time that had occurred. You'll notice that in the challenged order,
Wheeler?
Yes.
Yes. There's no doubt that the length of time in this case on the issue of relocation, that this was not dealt with expeditiously and in the time constraints that the statute or that the rule provides for. And so this case went on and on a life of its own, in effect. And I think what you're arguing is that the decision and issue on relocation was final when the court approved the general magistrate's report and recommendation and those findings.
Yes, sure.
The issue that I'm having a little trouble with, and maybe you can help me with, is that final order, and it is certainly clear that after that the court said, hey, this relocation will remain full in effect, but I have a problem with whether or not that was final when the court itself said, I think this is in, let's see here, it says it retains jurisdiction on, this is in the general magistrate's report, it says the court will not enter the final judgment until the petitioner has complied and provided the pertinent information. So whether the issue of relocation was final, I think those words in the magistrate's recommendation, which the court adopted, that there was no finality to the relocation issue.
Yeah, Your Honor, that segues into the 5th District's opinion in Westwood versus Westwood, which we cited in our supplemental authority and cited in our supplemental brief on jurisdiction. The Westwood decision says that such a judgment, which reserved in that case jurisdiction to determine child support as well as a time-sharing schedule, was still a partial final judgment. And then, of course, the Westwood's decision is trying to debate, well, what is filed after that? Is it a motion for rehearing, or is it in fact a supplemental petition for modification?
You're saying that this would have been a non-final appealable order that determined the rights and obligations under the rule. Is that what you're saying, that they could have appealed it at that time?
I believe it was final as to the issue of relocation. That the issue of relocation is distinct and severable and not dependent on any of the other remaining things that the magistrate wanted to discuss, such as a time-sharing schedule for the father. We've already determined conclusively where this child should be, Florida versus Oregon. So that was a distinct issue concluded by the order on rendered February 5, 2015. That's our contention. And then, of course, we start examining, well, what pleading, if any, did the father file after that would have justified the court examining anything regarding his right to have residential care of the child? And we find nothing. But where our focus is drawn by the arguments of the father is his, it's a very oddly phrased motion, but it's a motion for modification of trial court's ruling denying exceptions A and D to the magistrate's amended report and recommendation. And certainly when that argument was raised, the father was describing that as a motion for reconsideration. Excuse me, just one moment. And of course, no reconsideration will be necessary because we get back to the fact that the father never filed exceptions to the relocation report. That report was ratified as a court order on the 5th of February, and he doesn't file any exceptions until the 23rd. So clearly he's not filed timely exceptions. You can't file exceptions to a ratified report. So he's not filed timely exceptions. There's no reason to reconsider the ruling saying, no, we're not going to allow you to pursue those exceptions, those untimely exceptions further. He never serves, whatever that motion is, it's never served on the mother as required under 12.110 subsection H. And that's important because the father's then proceeding just pursuant to a series of motions. The pleadings are never defined, they're never confined. The mother never really even realizes that she's supposed to file her responses or defenses in response to whatever that motion is. And from there, the case takes on, as you mentioned previously, a life of its own. Going back to the general magistrate's recommendations and reports, there is no legal error in it because, bear in mind that this case was concluded through a final judgment of paternity in the Department of Revenue action that reserved jurisdiction to determine child support. But the entry of that final judgment, which did not provide a time-sharing schedule, gave rise to the statutory presumption as to what the arrangement should be under 742.031 subsection 1, which presumed that the mother...
We have lost Judge Atkinson. He has gone from the screen. He's back. Okay, go ahead, counsel. Thank you.
Thank you so much. The entry of that paternity judgment invested mother with all of the time sharing and sole parental responsibility until a court determined otherwise. Well, I would think
there was no counter petition filed, correct, by the father in that case for any time sharing?
He did not request time sharing. He did file a counter petition. It's very vague. But I would say, even, Your Honor, the entry of the final judgment of paternity concludes that counter petition in the paternity action, the DOR paternity action. The reality is he shouldn't have filed it in the DOR paternity action because they're not going to address time sharing or a parenting schedule properly. I think he should have brought another action to determine his parental rights and responsibilities in light of the determination of his paternity of the child. And he never does that. He never files a petition. The only thing that he's telling us is approximate to that is the motion for modification of court's ruling of denial of exceptions. So, Your Honor, I just wanted to mention one more. We have cited a supplemental authority that we filed very recently, this court's decision in Smith versus Smith in 2006. The Smith decision is factually different, obviously, but it's interesting because it does involve there a mother who files a motion to relocate with the child to Dade County. The father responds with a petition to modify primary residential care, which does not mention relocation. The court rules on the mother's motion to relocate, and the second district holds that ruling is binding. That what actually happened in the Smith case was the court denied the petition of the father to change residential care, but ordered that the child be returned to the original county of residence. And writing for the panel, Judge Silberman says that no one has cited authority that allows a party to relitigate a final order allowing relocation. And that's what we think we have, is a final order resolving the distinct issue of relocation back in February of 2015. Your Honor, if we are right, this would allow this court to reverse the opinion, the final order of relocation, and remand it with instructions to ratify the magistrate's report and recommendation. And a point I wanted to mention there, the circuit judge was concerned that the time sharing plan did not give the father adequate time, but that was within her discretion under Conacris. Reasonable people would certainly debate what type of time sharing a father needed with a 26-month-old child when he had not seen that child since she was 3 months old. He admittedly had no contact with her at that point, no bond, she was a complete stranger to him. So as you examine what the magistrate put in place, it seems that was intended to be a reunification schedule to segue into something greater if that went well. And under Conacris, it should have been affirmed. The only other thing that we would like to address is that if the court does reverse, as we are requesting, that would take care of the other complaints we have about the order, with the exception of the findings of contempt. The mother was found in contempt, we believe erroneously, based upon very vague instructions that would not be sufficient to hold her in contempt. The order that finds her in contempt is not sufficient to tell us how she gets herself out of contempt. And certainly, both of those orders, she was found in contempt for not following time sharing orders. And of course, we've searched through the record and we don't find any time sharing orders. It looks like they were really complaining that they felt, they were alleging she was not following the amended parenting plan recommended by the magistrate, which hadn't been ratified as an order at that point. And then of course, the second finding of contempt relates to her failure to get the psychological evaluation that previously was ordered. And of course, there's no finding she had the financial ability to do that. She had been ordered to do it in a certain way. And the finding that, when Judge Krug determines she should have done it, he relies on the psychologist's willingness to discuss a payment schedule. Well, that's certainly not part of the written order that she's been found to have violated. On that basis, Your Honor, I think I probably need to save my remaining time for rebuttal. And thank you very much.
Thank you. Clear. All right. We are at this point be appropriate for the appellee to respond. Attorney Black. You need to unmic, ma'am. You need to unmic your microphone. You still have your microphone blocked. You have to unmic.
Ms. Black.
You're muted. There we go.
Okay, sorry, I am not real technologically advanced, Your Honor, but I'm hanging in there. Good morning. Good morning, Your Honors. May it please the court, my name is Andrea Black. I am here on behalf of Keith Bono, the appellee in this case. And I've been in the case since 2016. Your Honor, one of the first things I'd like to address is the length of this time of this case. It's been going on 7 years. And one of the reasons why that's gone on that long is because there have been five previous non-final appeals in this case that have delayed it and that have, that among other things, judicial time and family law is just a unique kind of case, as you all know.
And Ms. Black, it is very unique. You're right about that. But I went through the record. I don't think I've missed a pleading. And so how can the trial court award time sharing to the father who has never filed a petition for such time sharing? I keep going back to the basics.
Well, Your Honor, the appellant filed a petition to relocate, asking for time sharing.
Let's focus on the
Okay.
father. Okay.
Well, he did. I'm sorry. He did file a counter petition,
Where?
and it was one of the original
Yeah, he
pleadings.
filed it in the child support case, but there is no petition that he's filed or counter petition for
in the child support, Your Honor. Well, Your Honor, it's my understanding in the Department of Revenue that handle that case, they don't handle time sharing at that time. They now do, but they at that time.
Okay, and so the case was then brought into family court after
Right.
the paternity case. And so
Right.
family case, I don't see any petition, counter petition to establish time sharing in his favor, other than when the exceptions come up and there's a modification motion that's filed. I don't see a pleading.
Well, I understand that, Your Honor, except that he filed a parenting plan at the request of the magistrate once they had gotten into the relocation. And my recollection, I have to be honest with you, my recollection is that he filed an objection and a counter petition asking for time sharing in the.
I don't see one in the record. If you can point one out to me and give me a record site, that would be good. The reason I bring this up is because when the initial order goes out from the trial court determining the issues to set the issues, there's a trial order that's sent out before the hearing on the relocation on the petition that's filed by the mother. And it says that it's for a final hearing. Let me get to it. It talks about a final hearing in the case, and it's on relocation. And so when that is decided, later on, there's notices of hearing that are done by the trial court after the general magistrate gives the report and recommendation, and the court ratifies that on relocation. But all the notices, and I'm getting to a due process question. So all the notices of hearing only talk about the modification of a parenting plan. I think it's the order setting hearing for the 4th of December of 2015. It's dated 10/15/2015. It says these issues are relevant to the court's ultimate decision on modification of parenting plan. And so going into this, I mean, there's hearing after hearing after hearing. And the notice to the mother is that all of this is on a parenting plan, because the court has said before, hey, the decision on the relocation will stand. Didn't just say that in the ratifying the order. I think it says it back in March of 2016, says that decision will stand. And so the mother goes into this final hearing, and the only order that talks about this final hearing says these issues are relevant to the court's ultimate decision on modification of parenting plan. How does she have noticed that the relocation issue is going to be readdressed and basically turned over?
Okay, well, here, first of all, I think you have to start, Your Honor, with the magistrate's ruling that was, quote unquote, approved by the court. That was the December 9, 2014 magistrate ruling. And in that, the mother had submitted a long distance parenting plan, and that was incorrect, that it had, and the court retained, the magistrate retained jurisdiction. This was not a final order. Therefore,
she did submit a corrected within that time period. Correct.
I understand.
Okay.
No, she did not submit it. Well, she submitted one. And then when she submitted the long distance plan, the magistrate filed 2 more reports. The next report was filed 2/11/15, I believe. And in that report, they attached a long distance parenting plan and my client's parenting plan, whether you called it long distance, it was a parenting plan.
But none of that changes the issue of relocation, that your client could have appealed the issue of relocation back when it was initially decided, and the exceptions were denied on those.
Well, however, Your Honor, I'm sorry, didn't mean to interrupt you.
I was just saying that in the March, I think it's the 26th order, and it pro-tunks it back to May of 2015, which is, I guess, some case management. But the order at that time, the court shows, that this relocation issue is final. There's nothing between that order and all these continued hearings to give notice to the mother that the relocation issue was going to be readdressed. And so if your client could have appealed it before, why are we still arguing about relocation?
I don't think he could have appealed it at that point, Your Honor, because the judge had already, and under the magistrate's ruling, first of all, I believe the exceptions were timely. And I'll give you I have that part even almost memorized.
But even if they were timely, they were decided by the court and denied. A&D
initially, but his order on its face said, this is a temporary ruling. The March 2016 order by Judge Walker was temporary. The basis of that was that the order entered by it wouldn't matter whether the exceptions were granted or denied. The court had an affirmative duty to determine if, in fact, what was presented to the magistrate on the parenting plans was in compliance with the law. It was not. And in fact, it was in effect a termination of his parental rights, because the mother had all the delegation. He had 1 day supervised. She decided what it was, and there was no pleading for sole parental responsibility. But in any event, on its face, this long distance parenting plan was so fundamentally opposed to the best interest of the child and Florida law that the court felt that the magistrate's order, with or without exceptions, even though I believe they were timely filed based on the time frame that's set out in my appellee's brief. So when they decided, and the order itself clearly says this is a temporary order. This is a temporary order that.
Where does it say that in the February 2015 order where it ratifies it? Where does it say that in the March 2016 order where it says the decision will stand on relocation?
It's right in what the court termed it, and they were to do certain things and come back.
On the parenting plan, it said it was temporary.
Yes, and
relocation.
Well, he called it a temporary order approving several of the magistrate's rulings. However, the on its face, I lost my train of thought now. He called it a temporary order. It was a temporary order because what he looked at was clearly fundamentally against the best interest of the minor child. I might also, the court, there have been a number of rulings for time sharing along the way, and there was no objection to them until we came to the motion for modification. But I would suggest to Your Honor that even if that's the case, then if Your Honor feels, I believe that the magistrate's order was clearly not a final order, and it only approved the 12/9/2014 ruling, which clearly says this is not a final order. So, and then the judge, in reviewing the parenting plan,
it said it wasn't going. It said it was going to reserve. It wasn't going to enter a final judgment, which I think is different than what is being the argument that is being made by the appellant, by the mother here, because she's saying that this still could have been a non-final appealable order, may not necessarily have been a final judgment on that issue, because the only reason that was being held up was because of the parenting plan.
Well, also that was not raised in the lower court. The only objection in the lower court on their motion to strike was on the basis that the exceptions were untimely and the court had no jurisdiction to review them because the exceptions were untimely, which I think both parts of those are wrong. I think the exceptions were timely, and the court did have the right to do that. And this court has affirmed a temporary order, which I treat as a ruling on the merits, the last temporary order for time sharing. The problem in this case, Your Honor, is our highest public policy is the best interest of the minor child. And the determination on relocation should be made at the final hearing. If you review all of the notices, they were final hearing, some requested by us, by the appellee, some requested by the appellant, but there were so many hearings. And, this reminds me of the case that out of the fifth, where the mother got arrested. Matter of fact, I worked on it for a while, and that was arrested wrongfully, but the child had lived for 2 years with the father who wrongfully had her arrested. And the court said, we have to determine now what's appropriate. That was an out of state. The child was allowed to be taken out of state and relocated. And I don't remember the name of it now, but it's cited in my brief. And and I feel like this is the same type of case. What has occurred over these years, one of two things. I believe there was clearly not a final order nor a non-final order that was appealable because no time sharing was there. It was a child support issue only in that, because the time sharing had not been put into the record. She had a time sharing for Oregon, not Sarasota. And the court also retained jurisdiction, the magistrate did. But let's assume for the moment that's not so. And the court looked at this and found that it had jurisdiction to make determinations, entered a temporary order, and with certain requirements and many temporary orders thereafter. Then with whether you call a motion for modification, a motion or a petition, even under those circumstances, if you're saying that this was not pled, this judge had the authority to determine time sharing. Let's say even the relocation, he could still, she relocate by herself, but the time sharing that she gets there is conditioned on certain things. I believe this court meticulously went through the findings of fact in this case, the whole case, and he observed the parties in court on many, many occasions. So, even if you go through that's something that should have been appealed, although I don't even think it was an appealable issue.
Ms. Black, let me ask you this: under the statute 61, the relocation statute 61.13001,
yes,
subsection 9 talks about the order of relocation.
Right.
In determining a trial court in determining relocation does not necessarily under subsection 9A have to give time sharing. Would you agree with me on that?
It may not have to be in the order, Your Honor. However, fundamentally in this case, because the magistrate required these time sharing parenting plans, which included the time sharing, that gave him the opportunity to evaluate whether the time sharing that were approved by the magistrate complied with Florida law. And I would suggest it did not right on its face. I mean, there's nothing about a parenting plan under Florida law that's governed by both 6113 and 61.3001, either one that complies with Florida law. So you could look at it and see that it wasn't that fundamentally it wasn't a proper finding, it wasn't a proper ruling by the magistrate. Therefore, he had an obligation to do something about it, because effectively what that did was terminate my client's parental rights. He had 1 day supervised by the mother. He had nothing else. He had no contact. She made all the decisions, and even the time for that 1 day, she was permitted to. And by the way, she submitted 2 different long distance parenting plans. When the order was entered for the approving the 12/9/2014, I believe that was just a form order. It wasn't one that the court had the opportunity to review the findings as to whether or not, because he's waiting for the parenting plans. Once the parenting plans came in and you had addressed them to the evidence, they don't comply with that, because the court found that was required further inquiry, entered a temporary order, and along the way it became extremely evident in the best interest of this minor child that a relocation or a time sharing with the mother was creating really serious problems as to health safety of the minor child. That, Your Honor, I believe is the key to this case. Always this judge has that ruling, had that right, and either the parenting plans or the motion to reconsider or the evidence that he saw with his own eyes gave him the ability, actually the duty, I believe, to do something to protect this child. That's what he did. Am I lost, or may I continue, Your Honor?
Absolutely. You still have time remaining.
Okay. How much time do I have remaining, Your Honor?
You're about to hit 17 minutes.
Okay. Thank you, Your Honor. When I talk about, they're talking about contempt, and I'll briefly touch on that, and the psychological. As far as the psychological, a review of this record over the 5 or 6 appeals that has gone through this court have shown that even if it had been a final order, there's not calling it a petition for modification, it's still a modification. The judge did in fact modify it, and this court did approve that in the most recent affirmed order that came out of the court for I think the 5th appeal that was done in this case. At this point, it's important that the court examine it from that perspective, even if you go back and say, well, I don't know that the magistrate's order was sufficient for the court to review. You still have, even if it was a final order, which they didn't bring up in the lower court. And I think that, and my position, Your Honor, is that the supplemental authority is the case that was in 2015, the Westwood case. And if they had that argument, it should have been made at the lower court so the lower court could address it. Judge Walker and Judge Krug both observed this mother in court, and they found the contempt in most cases was directly in court in front of the judge, who while I was there, saw her absolutely refuse time sharing, absolutely refuse to obey the court order. And that's what this case is about from the very beginning. It was to keep the father away from the child, to move as far away as she could, and during the whole time to the end, even at the very, very last, she would not agree to the court to any time sharing with the father. And her behavior in court was observed by the court. The defense or the appellant's attorney even advised that he thought a psychological evaluation was appropriate, even though he couldn't stipulate to it. The expert determined that that was viable, and the court had no other alternative but to protect this child. And whether you use it by his review of it, what was fundamentally invalid under Florida law for the magistrate, or you review it as a petition because it cited the motion, was called a motion, but you can call it a motion, you can call it a petition, and modification can be done.
Ms. Black, doesn't a petition, a pleading have, I mean, fundamentally, doesn't it have to be served on the other party?
Well,
you could call any motion.
He answered it. He answered it, so I believe
No. I'm talking about your client's motion for modification. You're saying that we should construe that as a pleading. And so I go back to the fundamentals of pleading, that you have to serve notice of that pleading on the other party so that they can appropriately respond. And so how can we, so am I correct that you're asking us to construe the motion for modification as a pleading? Because that's the only way that the court here could have ordered time sharing in your client's favor when he never asked for one before.
Well, no, I think he did ask for time sharing before. He filed a parenting plan for time sharing. And while it may not have been artfully, he was representing, I'm sorry.
Look at that. If we look at that long distance time parenting plan, he doesn't ask for majority because it's in the realm of the relocation proceeding.
But he still asked for time sharing, and whether or not that's what the judge thinks is appropriate. No time sharing agreement between the parties.
It's served by process on the mother.
Well, if the same way
to ignore,
I'm sorry,
that a pleading has to be served on the other party.
Well, first of all, I don't believe, my argument is that it's not a final hearing, not a final order in the first place, and that his placing time sharing in a parenting plan, which is evaluated and considered by the magistrate when it entered its ruling, he has the right to do that. But secondly, even if they, my position is that they essentially accepted service of the motion, whatever it is, by answering it, which they did. But I still do not concede that the original magistrate's order, which clearly on its face says I'm retaining jurisdiction, we have to file the long distance plans. They were wrong in the first place. There were two different ones. He did file exceptions. If you look at the time frames, you will see the exceptions were filed timely. They actually had a due process argument. The first report was 12/9/2014. The second report was 2/11/2015, and then thereafter there was an amended report, which was before the time period that he would have been able to object to it. He did file exceptions to the amended because if there was a due process violation, it was in favor of the mother. They didn't even give him time to object to the second one, to the second report.
Counsel, I'm required to stop you. We're well past 20 at this point, so I need to stop you. Thank you.
I appreciate it. Thank you.
And counsel, you have 5 minutes for your rebuttal. Attorney Wheeler.
Thank you, Your Honor. To respond to Ms. Black's argument, my client did not answer the motion for modification. She moved to strike it. And going back to that motion to strike is located at pages 1285 to 1300 of the record. It raises the exact argument that we're raising now. It's a wonderful little motion to strike. It was denied verbally. We never got a written ruling on that. But I just wanted to clarify that my client never answers that motion. Also, I wanted to point out that that's really not a modification petition on its merits. If you read it, it's more like a 1.540B motion that would be untimely because it's filed 16 months after the order of February 5, 2015. It's alleging misrepresentation of the mother It's alleging newly discovered evidence. Then it wants to talk about, quote, hospitalizations of the child, and 3 of those happened before the mother moved. So it's not truly a modification petition at all. To follow up on a point that Judge Smith made, the court is not just at liberty to decide residential care if that's never been a pleading that the party has requested. The time-sharing schedule that was cited was not correct. The magistrate did not award simply 1 day in the state of Oregon. I wanted to also mention that our argument is that the reviewing court, the circuit court, never should have been conducting these additional evidentiary hearings, which the court then uses as justification to say, I'm not adopting the magistrate's findings. It was a reviewing court, and it never, all of that was grossly improper. One more quick response to clarify what we have done previously. We have not taken 5 or 6 appeals. We filed 2 petitions for writ of certiorari directing to the 2 evolving orders about the psychological evaluation. One was dismissed, one was denied without comment. We filed 3 non-final appeals, and there's not any language ruling on those that would be a preclusive effect. So based on these arguments, we would request that the court reverse this final judgment granting relocation, which is grossly unfounded, and remand with instructions either to affirm, ratify, and confirm the magistrate's recommendation. I really think, and of course, to deal with the contempt finding. Thank you, Your Honors.
Thank you. Thank you both.
Thank you,
That will
Judge.
conclude today's oral arguments, and we are done. I know you have to exit, so thank you very much, and we'll let you exit. So I guess that we'll contact by Zoom.
Okay.
A few minutes. How long you want to wait?
We're on the live YouTube, just so you know.
Okay. Bye.
Bye.